This is Barry Zalma on Insurance. I am an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant, an insurance claims expert witness, an author and producer of these videos. Today it's time to speak about the California Fair Claims Settlement Practices Regulations and the requirement that every person, whether in California or not, that handles claims or may handle claims in the state of California must read and understand the California Fair Claims Settlement Practices Regulations. In 1993, complying with instructions from the California Supreme Court, the state of California determined that the insurance industry needed to be regulated to stop insurers from treating the people insured badly and without good faith. It created a set of regulations called the California Fair Claims Settlement Practices Regulations to enforce the mandate created by the California Fair Claims Settlement Practices Statute, California Insurance Code Section 790.03 (H). In so doing, the California Department of Insurance attempted to micromanage the business of insurance claims and create a method to punish those insurers who failed to comply with the regulations. Some of the regulations asserted what had always been recognized by the insurance industry and good faith and proper claims handling. Others imposed draconian mandates on what and when to do everything in the claims process. The regulations also provided a guide to insureds, public insurance adjusters, and policyholder lawyers to assert any violation of the regulations as evidence of an insurer's breach of the implied covenant of good faith and fair dealing. Shortly after 1993 and in various editions thereafter, I wrote a book about the Fair Claims Settlement Practices Regulations. The book was designed to assist insurance personnel who do business in the state of California. It was designed to assist all insurance claims personnel, claims professionals, independent insurance adjusters, special fraud investigators, private investigators who work for the insurance industry, the management in the industry, the attorneys who serve the industry, public insurance adjusters, policyholders, and counsel for policyholders working with insurers doing business in California. All insurers doing business in California must comply with the requirements of the regulations or face the ire of and attempts at financial punishment from the California Department of Insurance. That punishment is now questionable and limited because some courageous insurers fought the California Department and succeeded before an administrative law judge who limited the right to punish. For details about that action, you can read it in Chapter 3 of the book. Regardless of difficulties in assessing punishment, the state of California requires all who are involved in the claims practice and process, even if only tangentially, to be trained with regard to claims handling in compliance with the regulations, and attest to completion of such training under oath. To avoid the annual training, the claims person can submit a sworn document that avers he or she has read and understood the regulations. Reviewing this book I wrote called the California Fair Claims Settlement Practices Regulations should be sufficient to comply with the training requirements of the regulations. It is necessary that insurance personnel who are engaged in any way in the presentation, processing, or negotiation of insurance claims in California be familiar with the regulations. Counsel for insurers and policyholders should also be familiar with the regulations, since they set a minimum standard for claims handling in California. The insurer's lawyer will need to know and establish that the insurer fulfilled the regulations, since it will show to a trier of fact that the insurer fulfilled the minimum standards required. A knowledge of the regulations can assist the lawyer, whether for the insurer or for a policyholder, in evaluating the exposure faced by an insurer to a claim of bad faith breach of the regulations. Knowledge of the requirements of the regulation is important to everyone involved in the business of insurance, whether as an insurance adjuster, insurance claims management, public insurance adjuster, policyholder, defense lawyer, insurance coverage lawyer, and policyholder's lawyer. In 1993, the regulations came into effect. The first version of what was then called the Unfair Claim Settlement Practices Regulations, and were issued to comply with the direction of the California Supreme Court in a case called Moradi Shalal versus Fireman's Fund Insurance Company, which was issued in 1988. It took 5 years for the California Department to fully comply with the recommendations. Neither Section 790.03 nor Section 790.09 of the Insurance Code was, however, intended to create a private civil cause of action against an insurer that commits one of the various acts listed in Section 790.03 as wrongful acts. The California Supreme Court concluded the enforcement was the obligation of the California Department of Insurance, who eventually, after 5 years after the decision, issued the regulations. The 1997 changes, 2004, 2007, 2009, and 2012 changed the regulations, and they are now called the California Fair Claim Settlement Practices Regulations. The regulations imposed on all insurance personnel a detailed laundry list of actions that the California Department of Insurance considered wrongful or in violation of the Fair Claims Practices Act. The regulations imposed on all insurance claims personnel the requirement that they read and understand the regulations or attend an annual training program no later than September 1 of each year. Insurers are compelled to ascertain that every employee involved in any way in the claims process is trained about the regulations or has submitted a sworn statement that he or she has read and understand the regulations. The regulations even require that the insurance claims managing executive attest under oath that each employee has been trained with regard to and or understands the regulations. This requirement must be complied with in order to avoid the possibility of administrative penalties upon the insurer or prosecution of the officer for perjury. The records concerning the training and the filing of sworn statements by the insurance claims personnel must be maintained by the insurance company executive and must not be sent to the Department of Insurance unless there is a specific request from the department for the proof. The book contains the full text of the Fair Claims Settlement Practices Regulations in such a manner that it is easy to read, with commentary in brackets, bold, blue, and italic print to make clear the separation of the text of the regulations from commentary by the author. The commentary is designed to assist the claimsperson in understanding and applying the regulations. Insurers who flout the regulations have no right to gain a competitive edge on insurers who scrupulously follow the regulations and faithfully discharge their obligations to the insureds. Insurers who follow the law should not be put at a competitive disadvantage, particularly at the expense of insureds who may have valid claims. The regulations have made it easier for a litigant to prove an insurer acted in violation of the common law covenant of good faith and fair dealing and committed the tort of bad faith. Similarly, fulfilling the regulations by the letter can be used by insurers to defend against claims of bad faith. To do so, the parties must present evidence concerning the regulations in a manner that is believable and understandable to a lay jury. Most litigants present evidence regarding compliance with or failure to comply with the regulations by use of a claims handling expert. The expert will testify as to his or her conclusion that a party either complied with or failed to comply with the regulations. A claims handling expert, especially one with an insurer-biased history, who testifies that the defendant insurer violated the regulations, can be damning to the defense. Similarly, a claims handling expert who can testify that the insurer fulfilled all of the requirements of the regulations can convince a jury that the insurer acted in good faith. For example, during the course of a trial, an insurance expert testified as to requirements imposed on insurers under regulations promulgated by the California Department of Insurance. To emphasize the expert's testimony, the regulations were read to the jury by the trial court during the course of the expert's testimony. After the regulations the expert relied upon had been read by the trial court, the court stated, quote, "Now by virtue of this fact, ladies and gentlemen, that these things call themselves standards, you can treat them as though they are kind of acknowledged standards of behavior in the industry." The court's instruction, of course, was based upon the expert's testimony, and the wording of the regulation established that the regulations state a minimum standard for claims handling. Failure to fulfill the minimum standard subjects the insurer to punishment by the California Department of Insurance, not a court. However, failure to fulfill the minimum standards also allow a jury to conclude that if the evidence established that the insurer failed to fulfill the minimum standards, it probably acted in bad faith and was subject to tort damages. This video was adapted from my book on the California Fair Claims Settlement Practices Regulations, which is available both as a Kindle book and as a paperback from Amazon.com and from my website Zalma.com by clicking on the Insurance Claims Library link. If you found this video to be useful, please convey it to your colleagues and subscribe to my YouTube channel and my blog so that you can learn about future blog posts and future videos. Thank you for your attention, and please use the forms attached to the posting on this particular video. Thank you again for your attention.